Hi everybody, this is Arkady Frekhtman and I'm here with
Richard Mogg, trial counsel for the firm.
Awesome, and we actually received a call from one of our YouTube viewers like you, and this gentleman was in a weird type of accident, a car accident, and he had another lawyer and there was a top offer and the lawyer was saying, there's no way you're gonna get more than this offer. And the offer was $195,000, and this was in March. And last Monday, we took the case to trial. We started jury selection, and during jury selection, we settled this case for $2,200,000 and find out how. So let's get into it. Rick, tell us a little bit about the case.
Okay, first thing that I think is very important is where we got to the creme de la creme, as Mr. Frekhtman has said, we started at a very low number as an offer. The number was so low that we actually had to work the case up in various areas getting ready for trial. We actually started working on the trial in the beginning of March, and we wound up on the courthouse steps in June. Matter of fact, June 10th. All through that process, we were working up the case. And as Arkady says, you, the viewers, a lot of times don't know what goes on in the background for the preparation of a trial. This case involved a middle-aged gentleman who lived in the Bronx. He picks up his wife at a nursing home on the area called North Broadway in the Bronx, kind of near the Yonkers line. For the point of this case, they're driving down a street. And as they're driving down a street, unbeknownst to our client, there's a loose manhole cover up ahead. As the front tire of our client's car goes over it, it causes the manhole cover to go up kind of like a penny on its side and catch the undercarriage of the car, causing his van to pop up in the air, go about 3 feet in the air, and smash back down. As a result of that up and down quick movement, our client is about 6'1". So he was caused to smash his head on the top of the under part of the roof of the car, and then he twisted his low back to the left. And he wound up having very serious grave injuries. The lumbar spine was what's called a herniated disc at 2 levels. Eventually, he had to have surgery, and they had to open up his back and put hardware in the lower part of his back. Now, that's the general focus of the case and as it looked in a nutshell.
And actually, it's important to note also that this particular client was one of our YouTube viewers. He found us on YouTube, on this channel, and then he contacted me and we had a detailed consultation. He just texted me to 347-566-9595. We had a detailed consultation. We went over the facts of what happened. We went over his injuries, and then he already had a lawyer, but like we said, he had a low offer. I think the offer was only $195,000, and he was being pushed and railroaded into taking this offer. The lawyer was telling him, look, take this offer. This is an amazing offer. I have this is so much money. I have this offer for you. And, he didn't want it. And his wife and him came into the lawyer's office, and his wife, and him, they did not want this offer. And so the lawyer was basically telling them, well, if you don't like this offer, then, there's not much more I can do. And the lawyer was not a trial lawyer. He's never, I don't know if he's ever tried a case, but I looked in the jury verdict reporter and there were no results for him at all, no settlements, no verdicts, and he says he's been a lawyer for like 25 years, so that speaks for itself. But the point is that, we were happy that we were able to find someone like a viewer and able to help him, and you'll see like what we did with the case from the $195 final offer where the lawyer is telling him you can't get a penny more, and to the end result, which was $2,200,000. So it was much more than the $195,000 that he was being railroaded into taking. And so, yeah, I agree. Like what Rick was saying was exactly on point. He was just driving, and they're gonna go down the road to the Home Depot in the Bronx. The leftmost lane in the direction he's going is blocked. The second lane is blocked, and then the third lane is open. So he goes into the third lane. That's the lane closest to the curb. And then he's driving down, and then there's like a big gas station on the corner, and there's obviously like an entrance to the gas station. So cars and trucks are going in and out of that gas station. And at that lane, right near the gas station, there's a manhole cover, and the manhole cover is actually right near like the white lines, the dotted white lines that separate the lanes. So his left tire is going to go over this manhole. There's no way around it, right? Because the lane is pretty narrow. The car barely fits in the lane. And when his left tire does go over the manhole like pops up and throws his car into the air, and almost like, acts like a ramp. And his car goes up, and his head hits the top of the car, and his lower back slams, his whole body slams back into the seat. And so they all get out of the car, and they think, well, what's going on? They think that there's an explosion. They don't know what's happening. They all get out of the car, and then they see the entire manhole cover is upside down out of the access hole, and it's laying next to the hole because it was so loose.
Because of the craziness of this accident, our client actually got out of the car after being snapped up and back. He goes over to take a look at what happened. Who would know that it was a manhole cover that was loose? So what does he do? Takes out his cell phone, he takes pictures, and when we first met him, the first thing he said is, I took the pictures because I didn't think anybody would believe my story. And lo and behold, that's exactly what the defendants were trying to pull all along. One of the first things we did when we got the case is we poured through the transcripts. Arkady and I started to read the transcript. We saw what the defendants were trying to do. They're a utility company. And the utility company lawyer who represents these type of cases in manhole covers all the time, they tried a trick. And the trick was, the reason why Mr. Frekhtman brought up that right-hand lane is because they were trying to argue you didn't belong in that lane. That lane was a parking lane. That lane was a lane where you shouldn't have been driving, and that's why this accident happened. Now, it's a bogus argument, but if we didn't go through the transcripts and pick it apart, we wouldn't have known how to attack the case. Because eventually, as Mr. Frekhtman will explain along with myself, is we had to get experts on this case to fight some of the bogus theories that the utility company was throwing out there. And by the way, that lawyer from his prior lawyer, he did nothing in terms of hiring experts, having an expert evaluation on the medical side and on the liability side, which we'll explain as we go through this case.
Yeah, absolutely. Yeah, we had to hire a construction or a site safety engineering expert to talk about the manhole cover and the entire, the notice requirement, because they had notice about this earlier, and we proved that. So we had a safety expert. He went out to the scene. We had a whole report from him. He was going to testify, and he's a very well-known and has a very excellent reputation as a site safety expert, engineering expert. We also had an expert for biomechanical engineering, because one of the things that the defendants, the utility company, one of the things they did was at the last minute, at the 11th hour before trial, they all of a sudden served us with a biomechanical engineer who is a typical engineer that you see over and over again on these car crash cases. And what he was basically going to say is that the forces from this manhole being lifted up 3 feet could not have caused this injury, right? It's kind of some people say it's junk science, but biomechanical engineering, he's not a doctor, he's not a medical doctor, but he would have said that, right? And so we had our own engineer just out of caution. We didn't really even want to get one, but we thought, well, if they have one, let's get one too, just to counteract it. So we had our own engineer there.
Our firm specializes in trials. So when they put their expert on it, lo and behold, we actually tried a case in Nassau where we did a cross-examination of their expert. So we actually retrieved that transcript, and Arkady and I are reading through it, all the holes we found in his prior testimony in another case where he went against us. So it's not that we didn't feel comfortable without an expert, but with jurors, viewers, you should know, jurors will buy things from experts sometimes that are incredible.
And I found other transcripts where other lawyers cross-examined him. I think we had about 8 or 9 transcripts. And then the important thing about this biomechanical engineer expert was that, they didn't even serve us with a report. He never went to the scene. He never did any kind of investigation. He was just going to come in and generally say, based on my experience as a biomechanical engineer, that going up 3 feet, hitting this a manhole cover, I guess going 10 or 15 miles an hour, as the client testified, could not have caused a lower back injury. But the important thing with that is that in order to say that, they're basing it on scientific studies, like scientifically reliable studies. And most of the studies will involve cars, cars hitting each other. And there are studies, for example, when cars are going at really low speed and they crash into each other, like little fender benders, that let's say you take 1,000 people and only 200 of them get injured and 800, most of them don't get injured. So you could make the argument, well, scientifically you can't get injured because of, we have these studies. But no one has studies about cars going up in the air, right? This isn't Dukes of Hazzard. We don't have cars flying. So we were gonna probably preclude him on what's known as Daubert or Fry. We were gonna probably preclude him from testifying because he has no evidence to even support his contention.
I actually wanted to have him get on the stand, and Arkady was also, we were toying with it, should we put him on the stand or not, because we had some theories that went in our favor anyway. You see, a lot of people, when they see a type of accident, like this type of accident, they say, well, how is it he hurt his lower back if his car went up and down? Okay, there's something called, which our expert would have testified to, it's called the ragdoll theory. The ragdoll theory is, just think you're on a roller coaster. You're going up, you're talking to your friend, and as you get to the top, you and your friend go, oh, here it comes. You tighten up, and you strict your muscles and they're tight. When it goes down, you're ready. So the muscles take the sudden impact of the fall down. Well, our client, Mr. Salcedo, was sitting there. He wasn't ready for suddenly his car to go up and down like this. And because he wasn't ready, the ragdoll theory is the muscles are loose, and like a ragdoll shaking, you now rip and tear parts of the inside of your spine. So this biomechanical engineer theory going back and forth, it was important for us to get an expert just in case we had to go into those areas, and we didn't beat them on Daubert as Arkady was talking about.
And then the other part of it was that, how did they know, right? Because if you just have like a loose manhole cover, they can make an argument that you didn't prove any kind of notice, right? You have to prove notice, meaning that there was a danger and that Con Ed knew about it earlier and that Con Ed should have done something about it. And if we can't prove that, right, how do we know that the manhole didn't become loose like 10 seconds before the impact? Then they couldn't have possibly fixed it because it was fine. It only became loose 10 seconds before. So we had to prove notice. And the way we did that was basically I was going to talk about a Con Ed employee and say that, imagine you're in the Con Ed building, the headquarters in Manhattan, and you're in the building and a lady is there and she's a worker for Con Ed. And she receives a piece of paper. And this piece of paper comes from the New York City Department of Transportation, and it says, defect, driving lane, high traffic area, defective hardware. When cars go over this manhole, the manhole moves a lot. And it's known as a CAR, a C-A-R, a corrective action report. And she receives this, right? And this is 8 days before your Mr. Salcedo, our client, gets hurt. And she receives this. So as she receives this and it tells her, hey, this is defective, cars drive over, the whole thing is very loose, it's shaking. There's a photo in there. And the photo actually shows that the white line, remember I said there's a white line and it's a dotted line. The white line is so close to the manhole that the paint from the white line is on the manhole. But in the photo, the paint from the white line is not facing next to the white line, it's facing on the other side of the manhole. And that shows that, obviously if the paint is on the other side of the manhole, well, that shows you this whole manhole is being lifted and moving and circulating and moving because it's facing opposite side from the white line. So at this point, when she has this document, what can she do? She can call the construction unit of Con Ed to go out there and fix it, or she could do nothing. And then what does she do? And then we kind of left it a little bit suspenseful, and then we were going to take it to the story of how the plaintiff got injured. But you could tell she didn't do anything, right? I mean, technically by law, they do have 30 days to act. That was probably going to be their defense, that we have up to 30 days, but 8 days having this and not doing anything, and then I think that was enough for notice.
And to play off on that exact concept of them having notice, the attorney for the defendant kept playing on that whole theory of you're in the wrong lane. You're in the wrong lane, you shouldn't have been there. So what we did is, what we do as trial lawyers is we do what's called motions in limine. Motions in limine is a fancy way to say paper preparation before you get to court. Because when the defendants see you're prepared on certain areas before you even get there, you kind of make them alert on how prepared you are. It actually helped us with our settlement negotiations. One of the motions we made was to go to the accident scene. You have to meet certain requirements. But what I was going to argue to the court was, if they don't admit to liability since it was their manhole cover, they couldn't prove our client did anything to cause the accident. And this type of accident doesn't happen aside from negligence. They should just say, we admit it, it's us, we're liable, let's go to damages. They wouldn't do it. So we were ready with a motion to tell the judge, listen, if this issue keeps coming up as a confusion for the fact finder, for the jury, of which you viewers could be one day, we're going to ask by papers to go to the accident scene so they can use their hearts and their common sense and see who was right and who was wrong, how this wasn't our client's fault at all. Now, another important point here is, if you notice, Arkady and I are talking about how the accident happened, liability, who's at fault. In Bronx County Supreme Court versus other Supreme Courts, you have what's called a unified trial, where who's at fault, liability, and damages, what are the injuries, are tried all as one. And what that means is the plaintiff gets on the stand, he talks about how the accident happened, what his injuries were. Then the next doctor takes the stand, or the engineer, until the plaintiff's case is done, both on liability and damages. And why I'm bringing that to the viewer's attention is, it's not easy to break it down. You have to do a lot of preparation. So far, you've heard Arkady and I talk about the liability aspects. So what Con Edison knew once we got the file is, we were prepared to have our client testify as to how the incident occurred. We had backup testimony by his passenger wife, who was in the front seat, who also snapped up and down. We had photographs taken of the accident scene. We had the law on our side under the vehicle and traffic law, because it wasn't a shoulder, it was a legal lane. We also had a safety engineer that Arkady brought up, and we had a biomechanical engineer who can talk about damages and liability. And that's just half of the preparation we put out to Con Edison as the case started to move towards different numbers. We haven't even talked yet about the damages aspect.
So this was the liability, or who is at fault, part of this $2,200,000 settlement that we just did last Monday. And then the next video we'll do will be about damages and how this was all about the injury and all the interesting medical information. Okay, please like and subscribe to our channel. Thank you so much. Have a great day.